can we sit and believe that JAC, being their colleagues, can deal with this matter in a manner that reasonably convinces everybody that deep, detailed investigations have been undertaken? I'm saying that this is really not a matter for JAC to take too much time. It is a matter to go to Ethics and Anti-Corruption Commission, the CID department. But before that happens, I would have personally been happy with a situation where these judges of the Supreme Court, I don't know this problem with Kenyans that you must be in public office somehow as an individual. This matters, these judges in the Supreme Court, they live in the society. They know what the society already feels about the Supreme Court and more so the matter surrounding this allegation. For a credible judge, we ought to have upheld the institutional independence of the judiciary. These judges ought to have left. I mean, look at two of them. This judge does not want to leave. He has attained 70 years. Okay. The Deputy Chief Justice does not want to leave.
We're going into other things, Honorable Peter Kaluma. But before I come to you, Martin Olo, just one question to you, Kaluma. Why do you think they should leave? On what ground?
This allegation
because of allegations
shatters the independence of the judiciary. Public confidence has already been eroded.
So the bottom
they
line
would do well for the judiciary if they left.
Office because of what? Because of public confidence.
Public confidence is gone, and it is going. When they are there, they should go home.
I'll come back to you.
Mike, my fidelity is to the law. What I'm hearing has no legal backing or has no basis in law for any of the judges. And remember, even a judge of the Supreme Court or whatever part of the court is a Kenyan who also has his rights. He is an employee who also has his rights, and these rights are entrenched within the Constitution. So you don't apply different standards to a judge just because they're a judge. They must be treated just like any other person at law. Now that said, I want to submit to my colleague that you cannot use allegations as a basis to make such a fundamental decisions. And what is appealing to is not law, is perhaps morality. And this morality cannot just apply to judges. The other day, Mike, a Parliamentary Service Commission was accused of a few things. And it is the Ethics and Anti-Corruption Body, by the way, that went and did this investigation and gave a report. What did parliamentarians do? They woke up with such venom, threatened the Ethics and Corruption, and the report was hushed. They even threatened to lynch the speaker.
Actually, let me stop you there.
So why should Martin, it apply to judges and not to anybody else?
And this word that you're talking about, Honorable Kaluma, should apply in all. In today's Standard, the headlines is MPs crisis as 17 battle criminal cases. Are you then saying that they should quit? Because in one of those articles, the integrity crisis rocks Parliament. We have here Honorable Peter Kaluma, Homa Bay MP, also fighting fraud cases arising from land sale deal, and the story continues. Are you then applying the same for JSC, saying that Honorable Peter Kaluma then should also go home?
Let me answer this. Being before a court of law is not being a criminal. In fact, a court of law is one of the investigative bodies to find the truth. In good time, I don't want to go into that case, but I can tell you that is a case that I don't know where the lawyers of Kenya have been around. And it speaks also to corruption in the DPP's office and the problems.
Then why don't you want to make the same measure to
what I'm saying, and I think my friends are not understanding me. What I'm saying is that let JAC undertake their investigations. But let also bodies that can take those judges to court begin their investigations. What is wrong about that?
Actually, as a matter of fact.
Well, the point is, and I think I want to support the innuendo that has been given by my colleague here, that we have so many people who are facing criminal matters, civil matters. We have so many people who are facing other disciplinary matters, and you cannot adjudge them as if they are bad people until the conclusion of that matter. Correct. So therefore, it is wrong for Kaluma to insinuate that the entire judiciary should go just because of just one allegation. It is wrong. It is wrong. However, that does not mean that personally I do not have problems with judiciary. I do have. I have seen judiciary pronouncing itself in matters that I feel it was wrong. They ought not to have followed that kind of jurisprudence. Let me give you several matters. One, we have the CDF case, which appears to declare CDF unconstitutional. I felt it was a very erroneous judgment. We also have this other judgment which gave governors what we'd call the roads money. before even the constitutional time limit of devolvement has even elapsed. I think I also feel it was a very problematic judgment. Then also we have also another judgment relating to the issue of gays. They appear to have been given the right to open up a certain NGO. Again, I had a problem with that. But notwithstanding such cases that I feel they are stretching the jurisprudence of our legal practice, I don't think we should be rushing probably to say all judges should go. However, I think also we need to amend some of the laws that related to our judges. You see, the executive, after every 5 years, it has to go back and renew its mandate. Same way with parliamentarians. After 5 years, they have to go back and renew their mandates. This notion of giving judges jobs for life, I think even economists will agree with me, is not good. You need to come up with a situation where when you give so much tremendous power, and by the way, power which is being exercised by judges is monolithic. It is one person who is exercising power, as opposed to parliamentarians where they exercise it in a collegiate manner. So many of them making a certain decision. But here it is just one judge. Or, in the best of circumstances, a bench of not more than 7 people. So more often than not, it is 3 or even 5 or even 7. In such kind of situation, it is usually very easy to compromise such kind of a bench. And therefore, probably we need to borrow best practices in other jurisdictions. In some jurisdictions like Japan and even in America, some judges, by the way, seek popular mandate. I don't know whether it is time for us to do so.
Okay.
In other jurisdictions, they have what we call the jury systems, where they just make pronouncements on law, but on facts, you allow a certain entity that is more representative, that is more democratic, to make findings. And then the work of the judge is just to do a pronouncement.
Yes. Let me come to Martin Olo, and let's talk solutions. What needs to be done, given that, of course, there's a huge blow dealt to the judiciary right now? What's the solution for us to restore that confidence?
I think that for us to get to a solution to the judiciary, we must all sit back and introspect. Let's look at what is it that makes us get where we are. It takes more than 2 or 3 people to make a judiciary corrupt. It takes a lawyer practicing in that court to make that bench corrupt. It takes a prosecutor, or it takes a victim, or it takes a suspect. So basically what we are saying is that what we are seeing in the judiciary is a mirror of what is happening in the society. And in order for us to deal with it, we are not going to condone it, but for us to deal with it, we must not condone it at any levels. Remember, we are talking about the same issues of corruption in the counties. We are talking about the same issues of corruption in Parliament. In fact, when my friend Irungu says he has a problem with the judiciary and the case he's looking at is the CDF one, I'm smiling because you see that's an interesting case. I wish he left the issue of CDF, because as a member of Parliament and as a lawyer, I would expect that he will be very objective about it, but it's sometimes not possible to be objective when you have an interest. But there are issues that you can actually look at and you say, wait, the Constitution is being violated, or there are issues that are going to affect how we relate. So the solutions we have here, one is allow legal and the rule of law to take place. So if the Service Commission has said, look, we are doing preliminary investigations to establish, I don't think we should condemn them. We should actually be encouraging them.
But now, either way, whichever way this case goes, there's already public confidence that needs to be restored. Either way, whether it is found...
And let me say this now, and I want to go on record. I actually highly doubt that the allegations against Tunui hold water. I doubt that the allegations I've had and the statements I've had from a senior counsel like Ahmad Nasir actually hold water. And for that reason, we must be able to allow investigations to be very, very well done on this. Of course, what will happen is that after this, we will come back with our usual biases and prejudices. The fact of the matter is this: no Kenyan should be condemned unheard, should be condemned unfairly, should be condemned by mere allegations. If you look at the circumstances, including even the manner in which the affidavit has been done, and again, I want to challenge my legislators here, who are also my colleagues in the legal profession, are we missing a step here? Was it even proper in the first place for an affidavit to be sworn? If we want to move against a judge in the Judicial Service Commission, how should we approach it? Should it be a petition? I mean, there are things that we are seeing here that are actually playing to the gallery. And even as my colleague was saying earlier, I'm told, and I've not seen that, but I know that before the Chief Justice actually put this matter before, including the report that is put before the Judicial Service Commission, there are investigations from the NIS, there are investigations from the Criminal Investigation Department. And these are still just preliminary, because what we are saying is that, is there information that they want to put to the GSC so that then the GSC can test it and allow it for further investigation? So let us be a place where I would say we go by the rule of law. And the rule of law must apply to all of us.
All right, I want us to move on to something else. But finally, on this particular subject, Honorable Kaluma, what do you think would restore public confidence in the judiciary? Very briefly.
Yeah, we made a decision as Kenyans to have all judicial officers vetted. The mistake we made is that we committed the vetting to only judges or judicial officers who were there before the new constitution was passed. My view, and it is something we are looking into, is how we can ensure that all judicial officers, including the ones appointed after the constitution, are vetted. If we indeed vetted all judges, including the Supreme Court judges, then I believe these issues ought not to have arisen. So we need to open up the vetting process to all judges, including the ones appointed after the new constitution, and make it a continuous process. What I've noted in the judiciary is that once particular judges or judicial officers went through vetting, they are now saying they are working with the badge of integrity, and they are engaged in all sorts of corruption. But lastly, my view in terms of solution would be that we deal with issues like the one we are currently dealing with in a manner that convinces everybody that really due investigations have been done. Brother said NSIS has undertaken some preliminary investigations. The Criminal Investigations Department have taken some preliminary investigations. Let me hope what the Judicial Service Commission is doing is also just preliminary investigations, but that ultimately all these investigations and reports can go to Ethics and Anti-Corruption Commission, so that a decision is made by that commission, which has the best of facilities and the best of mandate to investigate matters, ethics and integrity.
All right, let's move on to something else. And we had the 26th African Union Summit, which took place, and we have the president giving a speech and a proposal that was given by Kenya to withdraw from the ICC, which was adopted with no amendments. And just as a refresher, maybe let's just have a clip of what the president had to say before I come to the panel this morning and see what the implications might be. And this is part of it.
When Kenya and the larger group of African countries joined the ICC, it was to seek legal means to complement the other important tools that we have, and we sought to combat impunity while being sensitive to the reality of our young and fragile democracies. We have been sorely disappointed, Mr. Chairman. Kenyans, including myself and my deputy, have been subjected to weak cases built on weak investigations and pursued with politicized zeal. There can be no recent illustration of this than the January proceedings in the case against my deputy, William Ruto, and journalist Joshua Sang. The prosecution seeks for the court to proceed without evaluating evidence. In any criminal justice system, these cases would never have come to trial. It is our expectation that the law will be applied and cases terminated. We have supported amendments to give effect to complementarity as a cardinal principle of the ICC. We will not and must not tire in this effort to reform the ICC. I therefore urge you to adopt the resolutions of the Ministerial Committee on ICC and include a new mandate to develop a roadmap for withdrawal from the Rome Statute as necessary. We must reaffirm that the global standard for impunity for heads of state should also apply to Africa, and insist on the termination of the collapse cases against the Deputy President of Kenya. Together, we can make a powerful statement that reflects our refusal to be carried along in a vehicle that has strayed off course to the detriment of our sovereignty, security, and dignity as Africans.